5 seconds to go. Start. Under section 342 of the Code of Criminal Procedure by the first subsection, insofar as it is material, the court may, at any stage of the inquiry or trial, and after the witnesses for the prosecution have been examined, and before the accused is called upon for his defense, shall put questions to the accused person for the purpose of enabling him to explain any circumstance appearing in the evidence against him. Examination under section 342 is primarily to be directed to those matters on which evidence has been laid for the prosecution to ascertain from the accused his version or explanation, if any, of the incident which forms the subject matter of the charge and his defense. By subsection 3, the answers given by the accused may be taken into consideration at the inquiry of the trial. If the accused person in his examination under section 342 confesses to the commission of the offence charges against him, the court may, relying upon that confession, proceed to convict him, but if he does not confess, and in explaining circumstance appearing in the evidence against him, sets up his own version and seeks to explain his conduct, pleading that he has committed no offence, the statement of the accused can only be taken into consideration in its entirety. Subsection 1 of section 313 corresponds to subsection 1 of section 342 of the old code, except that it now stands bifurcated in two parts, with the proviso added thereto clarifying that in summons cases where the presence of the accused is dispensed with, his examination under clause B may also be dispensed with. Subsection 2 of section 313 reproduces the old subsection 4, and the present subsection 3 corresponds to the old subsection 2, except for the change necessitated on account of the abolition of the jury system. The present subsection 4 with which we are concerned is a verbatim reproduction of the old subsection 3. Therefore, the aforesaid observations apply with equal force. Thus, the provision of section 313 for CRPC and the above authority makes it abundantly clear that if the accused during examination under section 313 CRPC makes any confession, the court may rely upon such confession for arriving at a finding with regard to guilt of the accused. What is evident from the examination of the accused appellants under section 313 CRPC in the present case is that the factum of the victim being assaulted had not been disputed by any of the accused appellant. They only tried to shift the culpability of assaulting the victim upon the other. Apparently, the accused appellants during their examination under section 313 CRPC did not confess to the commission of offence, but both the accused appellants, while explaining the incriminating evidence against them, sought to put up a case of their own to exculpate themselves. The question therefore emerges here is, in explaining the incriminating evidence during examination under section 313 CRPC, when the accused puts up a case of his own to exculpate himself, what shall be the effect of such exculpatory statement and explanation given by the accused during examination under section 313 CRPC. Apex Court in Narayan Singh versus State of Punjab 1963 3 SCR 678 as referred in Sukhdev Singh case Supra observed that if the accused in his examination under section 313 CRPC old section 342 confessed to the commission of offence charges against him, court may proceed to convict him relying upon such confession. But if he does not confess, and in explaining the circumstances appearing in the evidence against him, sets his own version and seeks to explain his conduct, pleading that he has committed no offence, in such case, statement of the accused can only be taken into consideration in its entirety. Therefore, one thing is clear, that when the accused confesses his guilt during examination under section 313 CRPC, court can straightway rely upon such confession and proceed to convict him on the basis of such confession. But when he does not confess, and in explaining the incriminating evidence against him, sets a case of his own to exculpate himself, in that case, not only the exculpatory portion, but his statement as a whole has to be taken into consideration. Each of the accused appellants in the present case, though, tried to set up a case of their own by shifting the culpability on the other. Both the accused have, in the process, admitted their presence at the place of occurrence and also the factum of assault on the victim. Thus, the statement of both the accused appellants in their examination under section 313 CRPC in its entirety reinforces the evidence of the PW4, PW6 and PW9 that both the accused persons assaulted the victim, causing injuries to him. Both the accused persons assaulted the victim, causing injuries to him. Stop.